Good afternoon and welcome to Licensing Subcommittee. I'll start by reading out some points from the protocol for remote meetings. Please only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you're not speaking, apart from the chair, who does not need to mute their mic at any stage. When speaking, please be succinct and do not exceed the allocated timeframes highlighted at the start of the hearing. If you are referring to a specific page or picture in a report, refer to the page number. If you are having technical difficulties, please use the chat function in Google Meet to alert the meeting. Please do not use the chat function for putting forward questions to the subcommittee. Any persistent disruptive behaviour will result in removal from the meeting. Applicants and all other parties will be asked to leave the proceedings after the item has concluded. Each party will be notified of the decision within 5 working days. Please could I ask the subcommittee to appoint a chair?
Can I propose Councillor Pluvier?
And could I second that, please?
Great, thank you, colleagues. Right, we're here for subcommittee and the order of business is we've elected a chair. Do I have apologies for absence? No, we don't.
There are no apologies for absence.
No apologies. Are there any declarations of interest from members? Not for myself? No. Thank you very much. Okay, in that case, we'll move on to the licensing subcommittee hearing procedure, which is near the beginning of the agenda. I hope everybody has that. We've appointed a chair. The item we're looking at today is the application for a shadow premises license for Hoxton Square, known as, I think, GG's, but I'm not sure. I think so. I'd like everybody now to introduce themselves. I will go through the list and ask you individually to introduce yourself, if that's okay. I'm Councillor Emma Pluvier from London Fields Ward. I have a colleague, Councillor Root.
I'm Councillor Penny Root. I represent Victoria Ward.
Thank you. Councillor Snell.
Councillor Peter Snell, I represent Dalston Ward.
Amanda.
Amanda North from Legal Services, assisting members. Thank you.
Thank you. Peter.
Peter Gray, Government Services.
Thank you. Suba.
I'm Subhashri Ramana, Principal Licensing Officer.
Okay. And just also from the council, we have Mario, who is handling the IT, who helps with all these committees. So thank you, Mario. Okay. We have for the applicant for the shadow license, David Dadds, I believe.
Yes, hello, councillors. I'm David Dadds and I'm here for the applicant, and to my right, virtually, I have Mr. Daly.
Okay, virtually, Mr. Daly. Sorry, I don't see. When you say virtually,
I mean he's next to me on another device, on another computer screen.
Okay, so he's actually with you physically rather than on my screen.
Yes, that's right.
So on my screen, I also have from the premises. Anybody else in your application, Mr. Dadds? Are there people here from the premises, or is everybody else another person?
No, it's just I'm here with Mr. Daly, the applicant. So right. I don't know if anyone else is here. I'm just here for the landlord, in effect.
Okay, thank you. So in that case, I can see John Parmiter. Hello, you're objecting to this license? That's correct, thank you. And Manzila?
Hi, I'm from Hackney IT, just observing today.
Thank you. Karen Bell?
Yeah, I just written a letter of sort of discontent with the application.
Okay, thank you. And then there's a telephone number, 791. Hello? That's it.
It's *6 on a phone keypad to unmute.
Okay. It's on.
Can you hear me?
Yes.
Yes, so Hoxton Square resident just keeping my identity confidential for now.
Okay. And are you wishing to speak?
Yes, please.
And John is wishing to speak, and Karen. So I've got 3 people objecting who want to make representations. Is that correct? John?
Yes,
Yes.
I'm representing the person on the phone that just spoke. So we anticipated sharing the 5 minutes between us.
When you say you're representing, do you mean you will speak instead of?
No, in addition to.
In addition to, okay. So I have 3 people who want to speak. Fine. Mr. Daz, did you want to?
Yes, please. Could I just be told the representation and the page number, so I can, when the parties speak, I'm able to look at their representation, please?
Okay.
As I don't have the identity.
That's fine. No, resident of Hoxton Square. Can we know what C number your objection is? In the they're B. Sorry, I beg your pardon. They're all appendix and then B number. If you could tell us which appendix number you are, that would be really helpful for Mr. Dadds. Uber, do you know?
And it would be helpful, I take it, Madam Chairman, that Mr. Parmenter has also written, so if I could know his page number. It's just so then I know what I'm referring to, if you don't mind. Thank you.
Of course. Well, I'll ask if we're going to proceed with this and you're happy with that, then I will ask them to identify the B number when they speak. Is that okay? Okay. Suba, did you want to add anything?
Oh, I just want to give the B numbers if required, or I can do it later, Chair.
Okay. Okay, well, it looks like we're all happy with proceeding on this then. So in that case, thank you very much. I will ask the licensing officer to outline the report, please.
Thank you, Chair. Licensing service are in receipt of an application for a premises license under Section 17 of the Licensing Act 2003 for 11 Hoxton Square to authorize the supply of alcohol for own sales, regulated entertainment, and late night refreshment. The application is described as for a shadow license. I would like to clarify that there is a minor error within the report on page 3 of the online version. The Sunday commencing hours should state 9, not 90. Representation remains from the other persons. I have nothing else to add.
Thank you. Okay, if we don't have any clarifications, we'll go forward and hear from Mr. Dadds.
Thank you, Chair. The application is as set out in the agenda. The application is for a shadow license, in other words, on the same terms as the existing license. It's for the landowner to have a shadow license and hold in their own name, which is, as you'll be aware, and your legal advisor will advise you, is lawful. In relation to representations, there are no representations from Environmental Health, the Planning, Environmental Health Enforcement, the Health and Safety, Weights and Measures Planning, Child Protection, Fire Authority, Police, the Licensing Authority or Health Authority. Obviously, I understand that there are some residents who have raised objection. I've looked through those. Principally, there may be some confusion around the shadow license. Obviously, this is not a review of a license, as we all know, and the Mr. Daly is applying, which is lawful for him to have a shadow license on the same terms of the license that's already in existence. And I draw to your attention the police's representation and comment whether they withdrew with an agreement that the license will duplicate the license in its current form and it gives the license number. There are a number of matters I think we took out which were duplication by other statutory provisions are no longer necessary, but we left them back in and just left it there in any event, so that there was no doubt that this is on all fours a shadow license. And in effect, that's it. My client is not going to operate it insofar as it's a shadow license. So the landlord, obviously, the purpose of it is he collects rent, but obviously in the future he has and retains the license which was originally granted to him years ago. So as a landlord, he is holding a duplicate license. And unless I can assist you further, I mean, it speaks for itself, and I don't think I can't comment about the current license and the current operation because we're not involved.
Okay, thank you, Mr. Dadd. Councillor Snell, did you have a point to raise here?
We could ask Amanda, but we might as well ask David Dad's this one. As you will know, we do worry if there's more than one license for a particular area. It just causes confusion. So very often, when a new licensee comes along, we get them to agree to let go the old one. I think this is the first time I've done a shadow license, but can you say, is it something separate in law that means the problems that we sometimes fear, that we've got two people, no clear responsibility for putting licensed activities on, is somehow avoided in the shadow license? It's a different provision from basically having two ordinary licenses on the same premises. Have I got that right?
Yeah, I can understand what you're saying. The position is that we would in any event, we're quite happy to notify the local authority if we are activating or going to be using the license. I'm quite happy to say that, just as a note. But it's the case law is oyster fleet, where the landlord who's collecting rent is entitled to hold a shadow license. So for whatever reason, for example, I have had cases, I'm not saying that this is one of those. I've had a case where a tenant has gone insolvent, for example, and then the landlord has not been able to get the license back or hold a license. So there's going to be no concern regarding who's operating it, because we will write saying we're holding it as a shadow license as the landlord, and I'm quite happy, Councillor Snell, if we activate it and we actually operate it, we'll notify the licensing authority. So in effect, the other license will not fall, but won't be in operation, because I expect the only way we would ever operate it is that we give notice to our tenant and take back the premises.
Okay. You mentioned, Mr. Dadd's, sort of updating a couple of the conditions. We noted in condition 15 that we would want to remove the end of that sentence as in line with the council's licensing policy LP7, because that's no longer relevant. It's not the right LP.
What page number is that, madam? Sorry.
I don't know, because I'm so sorry. It's the conditions
that I offered 15.
I think it's always condition 15. So it's either you can take them from the current license right at the back, or in the application details, it's in the conditions derived from the operating schedule.
Yes, I'll go from the license at the back. So
okay,
yeah, that's fine.
Are there other alterations that you felt needed to be made? Because you did mention
there were, because it's what I'll do, if you bear with me 1 minute, I'll look back at my original note, because there were some that just were redundant by passage of time that no longer are required. But I'll quickly dig those out now, and I'll come back to you in a minute if you can, if we carry on, and I'll okay. Then. Is that all right?
Yes, that's fine. That's absolutely fine. I mean, it's just tidying it up. But okay, all right. Thank you. Are we? We're done with the applicant's case, and we're all no more questions from councillors on that. Okay. Right. In that case, we move on to the objectors. Now, in terms of the objectors, I'm really happy for you all to speak, but I think it's really important that I do draw to your attention the fact that this isn't a review of the license, as Mr. Dadds has already said. I think it's really important to say that now, and I'm happy. We're happy to listen to what you have to say, and that will be noted. But it's basically, we will add our feelings if we think so. But one of your objections calls for a review, and that isn't what this is, and it doesn't lead to a review of the current license. It has no, in effect, it has nothing to do with the current license. This is simply a request to produce a shadow license, and it would be inappropriate of us to do anything that reflected the current license in this hearing. So on that basis, I'm really happy to hear your objections. And who would like to go first? Any volunteers? And when you speak, please refer to your objection appendix number, if you don't mind. John Parmiter, would you like to speak first? Seeing as I can.
I'm happy to do so, just for and then followed by my client. And mine is on page 46, I believe, of the PDF.
It's helpful if you can give us the appendix number at the top of the page, B whatever it is.
Oh,
Sorry, Chair, it's B8.
B8. Thank you, Suba. Thank you very much.
Very much. Thank you for that. And I do appreciate, Chair, that this is a shadow license. The review is just simply a in passing comment. We may well come back to that. But the fact is that we think there is a sufficient likelihood of the landlord taking control of the premises in the future to therefore activate this license, that we need to speak to this license application, because Mr. Daly obviously operated it for about 15 years before the current license. And I'm just dealing with procedural. My client will deal with the actual experience of the license in Mr. Daly's hands. I'm pointing out really two things. One are the policy objections. In the application form under section M, it says, describe the steps you intend to take to promote the 4 licensing objectives. These aren't spelt out. There was no response to the licensing objectives at all, simply a set of conditions. And I don't think that's the appropriate way to deal with your licensing policy, particularly LP3, core hours, LP6, external areas, and LP5, planning status, which takes me on to the second limb of my comments, which are, you need to know there is no planning permission for the licensable activities in the basement, nor for the outside seating area at ground floor. That's all I have to say, Chair. Thank you very much, and pass over to my client, who's on the phone and whose identity doesn't want to be identified.
Okay. Hi. Can you hear me okay?
Yes.
Hi. So yeah, I totally understand this is a shadow license, but it's also a chance as a resident to also let you know.
Can I just before you just to clarify your B number, if you don't mind, or Suba will tell you.
Yeah, it's B5.
It's B5.
Thank you.
Yes.
Lovely.
So it's not often that I get the chance to speak in front of the licensing committee, and this is obviously something that directly influences my life on a day-to-day basis. So I'll try and just keep as succinct as possible, and I hope that all of it's okay to say, so I'll just try and keep the point as much as possible. So thank you for letting me speak. I really appreciate it. So I am a resident and I live directly next door, and I'm objecting essentially on grounds of disorder and public nuisance. It's a fully residential building, and I've lived here before the restaurant and bar was built. I've lived here since 1999. So as you can imagine, I understand the area very well. But all of this has a direct impact on anyone who's living in Hoxton Square. So it was opened in 2003, and it is a mixed area of residential and commercial properties. And we had noise tests originally done in 2006. And then for 13 years, actually the noise issues got a lot better with Mr. Daly, but we did still experience antisocial behaviour that was just simply ongoing. And this is intimidating behaviour from patrons, car bars, crime disorder, and my lived experience is, it can be really intimidating just to go outside in the evening. I'm going to go through as quickly as I can. Giovanna Hussein took over the licence in 2019, and all the problems started again with amplified music, with doors being left open. All of that started, so they were in breach of a lot of the licensing conditions, things saying that doors needed to be shut and that noise should be inaudible. So particularly given the historical context that this is solvable, that does need to be addressed. Leaving these issues, means that we can't sleep, sometimes till 3 a.m. when the bar's shut. We do appreciate the current licence holder, Giovanna, setting up a WhatsApp group. But again, because the doors were left open, we were told it was a fire risk issue. No solution was found. And so it just kind of left us in this situation. We realised this has been happening since early 2020, before the lockdown. We're on certain times now. We totally appreciate the need of restaurant and bar owners to revive their businesses and survive. But obviously we live here too. And we work from home, and and it matters that we can also have a quality of life. So with COVID safety, that all of those issues may affect licensing conditions, whether the doors are open and all of those aspects. And I think actually the licensing conditions are really, really important. And I remember saying that historically maybe some of them are redundant, but are they? And can we definitely look into all of this in terms of how it affects residents? So it just felt, from our point of view, by simply reinstating the shadow licence, it won't address these issues. And we just felt it was really reasonable to call for tighter conditions and actually look at this again, just because of the experience that we're having. But to say, it's really important to me and all of us who live here to maintain good relationships with the bar owners. And we do want to work with them to resolve all these issues. So yeah, I just wanted to add that too. And we do want to maintain good relationships, but there is a lived experience, when you're living right next door, that I really, really want you to hear, and hopefully we can resolve all these issues.
Thank you. Does anybody have any points of clarification on that? Councillor Snell, your hand is still up. Is that what we call a historic hand?
Apologies for that. Yes, sorry, I should have put that right. Let me think. Not at this moment.
Okay.
If I have anything, I think it's in the discussion phase.
Councillor Root, did you want to?
I did just want to ask whether or not this resident has ever made any kind of formal request for a review of the licence in the past, or has made any complaints about noise, etc., to the council in the past.
Initially, when the bar first opened in 2003, we went through a number of years of complaining directly to the council until the noise limiter was put in place in 2006. And as I mentioned before, actually the amplified music, that issue got a lot better for 13 years. So Mr. Daly did, address that. Obviously, what isn't addressed and is an ongoing problem is the antisocial behaviour of sort of what happens when people leave the bar, and that issue. But the real problem was then the new licence holder, Giovanna, taking over in 2019, and it almost felt like we went back to square one in 2006, and we literally couldn't sleep at night. She set up a WhatsApp group with us, which we were very happy to do, and we met with her, but it just felt like we were going round in circles because we had the noise limiter installed again in 2019, and then she was leaving the doors open. So it was just really, really difficult. And then, of course, we've had a lockdown. And so from kind of 2020 to now, we've not been in normal circumstances. So I think the answer to that is we've been trying to cooperate directly with her. And actually, this is the first time since then that I've actually had the opportunity to share some of this with the council simply because of the unprecedented situation we've been in with the virus. And just to say again, we do want to sort this out, but I just think it's really important for you to hear that there are residents here, but we do want to cooperate and sort it out. It's just that fear of what happens when things reopen. Are licensing conditions going to be different? How does the virus affect everything with amplified music? So it is quite complex and detailed, but it's just something that needs to be thought about, from both parties' point of view.
Okay, so just to be absolutely clear, in the past you have made representations about noise, but you've never. I mean, even and despite the fact that leaving doors open would appear to be a breach of the current license, you've never actually written to draw that to the council's attention in the licensing department.
So as I said, of recent times, the bar's simply been shut. So it's not been normal times, and really the issues that were going on have been kind of sporadic over the course of when the bar's actually been open the last few years. And they've only started up since 2019. At first, we just cooperated directly with the bar owner to see if we could sort it out that way. And yes, so we haven't as yet. And if, for example, things go back to normal and the doors are open, I think myself and the residents feel that we have asked the question so many times in the WhatsApp group, why are your doors open? We tried to, cooperate as much as possible because I do think that's the best way to go. But I think in the future, if the doors are open and there is amplified music, we will start writing directly to the council. So you're kind of asking a question in quite an unusual time where we're not living in normal times. But that's the best answer I can give you at the moment, is that we've tried to cooperate directly. And if it doesn't succeed that way, we will be writing to the council directly. And this is also a chance for me to let you know. So I hope that sort of sounds reasonable and makes sense.
Yes, thanks very much.
No problem.
Thank you. Thank you. I think that's all the people we have here on the call to speak. So we're in the discussion phase. Perhaps it would be useful to ask Mr. Dadds if Mr. Daly could do anything to help with the current situation, or maybe that's not appropriate.
Well, in fact, Chair, I was just talking to Mr. Daly about, can't we write to the tenants, say, close your doors? So we will write.
Okay.
I mean, obviously, we can only deal with the lease. We're not there to enforce, but
Sure.
I think we can enforce the lease. And certainly the residents sounded very sensible, very reasonable. We will reach out to try to maybe have discourse with her or the agent, and we will write to the tenant and say, please comply. We can't enforce, and it's not our responsibility, but we will certainly do that because I think that sounds very sensible.
Okay, thank you very much.
Thank you.
Anything else people want to raise in terms of discussion or questions? Okay, I think we've really got to the core of this. Thank you very much, everybody. Does anybody want to make any closing remarks? I'm kind of assuming...
I ought to perhaps come in with observations, if I may, Chair.
Yeah.
I mean, just some thoughts. I raised earlier on with Mr. Dadds this issue about would he notify us so we knew if there was a change of the licensee. And he's offered to put that clause in. I'm now a wee bit confused because listening from John Parmiter and the Hoxton resident, it sounds as if when Mr. Dadds was running it, it was actually run better. And if anything, it's slipped since he's had somebody else running it. So, I think from the council's perspective, as long as we know who's in charge, that is useful because then we know who to be taking action against. But there's almost sitting on this committee, and perhaps John might want to address this in his concluding remarks. It sounds as if actually it's got worse, that not having Mr. Mr.
Daly
running it means that it's not been as good as when he was running it himself. So it's not giving much grounds for objecting to this. Even the other thing I might say, John, if you're going to come back on this, is also I see the planning issues. I mean, perhaps David Dadds can address this in his summing up, but we are always very happy to put a planning informative on any decision. But ultimately, we don't decide on the basis of planning because that's a separate committee with separate rules. But that can address those concerns that the planning is not sufficient for the current use of the building. So I'm just setting out my issues. Please pick them up so we can conclude.
Sure. John Parmiter, yeah.
Thank you. I think it would be wrong to get the impression that it's got worse. Therefore, if we go back to Mr. Daly, it'll all be fine. I think what the objector was saying is that the noise, i.e., through the noise limiter, the noise was solved, but the public disorder and public nuisance was ongoing all through Mr. Daly's license holding. Please don't be under any misapprehension that it's all going to be fine if it goes back to Mr. Daly. On the planning, it is actually one of your policy considerations, LP5 planning status. It is something that your own licensing policy asks you to take into account. And I think it's really quite serious if the nightclub, which is one of the primary causes of the public disorder and public nuisance, hasn't got planning permission. It's all very well putting an informative, but the problem's been going on for far too long, and nobody's done anything about it. I mean, I'm instructed to do something about it, but it's all very late in the day.
Right. So I'm not quite sure what you're recommend. I mean, it's not possible for us to do very much about it as a licensing committee. Mr. Dance, would you like?
My conclusion would be not to grant the license.
Okay, thank you. You did mention two aspects. You said the basement, and then you said something about the outdoors as well. Was because that's not always a planning thing. That's sometimes a street.
Yes, well, it is a planning thing in that they don't have planning permission for the new outside seating area. And again, this is something that is part of your policy LP6, and it's related back to LP5. Because it impacts the way it's worded is the licensing authority will normally restrict external areas and outdoor activity to between 8 and 2,200 hours.
Yeah.
And then the applicant's got to actually show why. But if he hasn't got planning permission and is breaching the conditions in the previous and current license, I don't see how we can be reassured. Hence our request to the committee is to reject the application.
Yeah, but the problem is that if he's in breach of planning, then that's a serious matter, but it's for planning to take action on that and complaints to be made to planning, and we can make an informative on that. If it's a planning matter on the street seating license, it might be, it might not, it might be a street license thing. If there are breaches in the licensing conditions of the use of the outdoor space, then complaint must go into licensing. I'm sorry to be, but Mr. Dads will pick me up straight away if I'm not clear on this. So I'm trying to do that, and I'm afraid I'm still. I think we're probably not sure that trying to alter a shadow license is the way to deal with these quite serious matters that you and other people have raised here, both in terms of planning and in terms of licensing. It seems a roundabout way to try and adjust a shadow license when you're talking about offences under planning. That should be dealt with properly, and all we can do is issue an informative to that effect.
I understand that it's a side issue, and I'm just simply raising it as for your information, but the fundamental issues of public disorder and public nuisance will not go away with this shadow license, and we should ask that it be rejected, not amended.
Okay. Well, okay. Well, we'll certainly hear that. Thank you. But I reiterate that complaints about the current license in terms of the management of the premises must be directed to licensing. Thanks. Mr. Dads.
Just a couple of points, if I may, Chair. The point that I was referring to earlier on, I think it's condition number 20. I felt that I removed that in the application, but said to the police I would put it back if they wanted it to be exactly a shadow, because I thought that condition was redundant, because obviously it came in, I think, over 10 years ago. So, but it's a matter of you if you want to replicate it or not. But I thought I would just raise that because it's somewhat redundant.
Is that the one about building control?
Yes.
So was that done?
Yes, I believe it was done at the time. Yes.
That would
I mean, it was over 10 years ago.
Explain the improvement in the noise if it was done.
And, in fact, and I think that if I remember, that I think that was in 2005.
Yeah.
I think I went back in 2011 and got the extension to 3 o'clock. So in fact, it sat on the license for years.
Okay.
So it was just a tidying up exercise, but whether it stays there or not is in relation to the planning. As you know, the Woodhouse case is quite clear that there shouldn't be a duplication between the licensing and planning. The planning authority have been consulted with the application and raised no objection. I don't agree, unfortunately, with the resident in relation to its class use. It does have class use for A3, A4 drinking establishment. He calls it or gives it a a class use in relation to a nightclub. And it's not that, it's a drinking establishment. So, but obviously, if there is, if he or his client believes that there is a breach of planning control, I think you're correct in directing them to the planning authority to look at that. Based on the information present before me, I don't believe there is any breach of planning control. But obviously, if they raise it, and he can also write to us too, as the landlord, we'll look at it and respond. In relation to the issues around public nuisance or noise, likewise, if there's an issue with the operator, then the right course of action is to use the agent or go directly to licensing or noise control and register that complaint so it can be looked at. I don't dismiss it, but obviously that would be the right and proper way to address that if it is corroborated and substantiated. All I would say is this is a shadow license. The landlord will speak to the tenant and will write to the tenant regarding the doors. In relation to the position of use, as I say, notification, I'm quite happy for an informative on the license to say if we're using it, we'll notify the local authority that we're now engaged and we're using it. I'm quite happy as an informative to offer that. I believe that that's dealt with Councillor Snell's point, I hope, and picked up the other points that were raised. I have no further matters to raise or say.
Thank you. Anybody else have anything they want to add? So, Mr. Daz, is that your summing up? You're happy with what you've had to say now, unless there are...
Yes, that's correct.
Answer. Thank you. I mean, the only thing I wanted to just say is condition 16 does clearly say as a licensing condition, doors should be kept closed at all times regulated entertainment is underway. And so the residents are suggesting that the license current use of it is in breach.
If I have time this afternoon, I will get a letter out to the tenant. If not, it will be on Monday morning.
Yeah. Okay.
But I'm in a trial tomorrow.
Okay.
Thank you.
Councillor Root.
Yeah, this is just a clarification, really. Right at the beginning, Mr. Dad said that the only way that the client would expect to operate this shadow license would be if they were going to give notice to their tenant. Now, there's nothing that they've said within this hearing that's led me to think that they are planning to do that, but I just wondered whether or not that is an intention of the landlord or not.
No, I think you may have misunderstood. I'm sorry, I was just giving scenarios. It can be that the tenant becomes insolvent or without capacity, which is out of our control, or alternative, the landlord can give notice. So, but there's no intention of any of that at this moment in time. It's just to hold a shadow license. There's been lots of restaurants going and premises going because of COVID, and obviously making sure that the landlord's interest in relation to a license. That's why lots of landlords apply for shadow licenses.
Okay, thank you.
Councillor Snell.
Before we move to consider our decision on this, I just wanted to get a quick bit of legal advice out in the public arena, if Amanda's on the call. Basically, if people are after a review, I'm sure it'd be very helpful if we could add an informative that just explained the process for seeking a review of the licence. Would it be appropriate to add that as a public informative at the end of any decision we make?
Yes, I mean, because the local residents have powers to seek a review, and they could make their representations to the licensing authority, who would then investigate any concerns they have. And if they felt it was there was sufficient evidence there, they would call a review, and other responsible authorities would be notified about it, including the police. So yes, an informative can be put there to say that they have that option to exercise that if they wish to. But obviously a review is not relevant in these proceedings.
Okay, right. Well, in that case, Mr. Daz has indicated that he's said enough. John and Hoxton Square residents, is there anything else you wish to say in summing up, or are you happy? No, you're happy. Okay. Okay. Right, well, in that case, unless there's any final clarification, we will ask everybody to leave other than the councillors and legal advice, and we will make our decision and you will be informed of it. And thank you very much to everybody for coming along. And
thank you. Goodbye.
Thank you.
Thank you.